the court. My name is...
1 second.
Okay, sorry.
That's quite all right. Okay. The next matter we have is Normandy versus American. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. I want to thank counsel for coming in and doing this argument virtually. We really appreciate it, and I assume that you received the guidelines for oral argument on virtual platform. Is that correct?
Yes, Your Honor.
So thank you very much.
Yes.
But before we proceed, I just want to make sure that everyone understands. Sometimes you won't be able to see the justices, but you'll see either the virtual hand or you'll see them raising their hand. When that happens, if you can please pause your argument and then I can call on that justice to ask their question. I'd greatly appreciate that. Are you ready to proceed, counsel? Okay.
Yes, Your Honor.
Please identify yourself for the record and let me know if you wish to reserve any time for rebuttal.
Yes, Your Honor. May it please the court. My name is Jacqueline Fusco from local Leiden, and with me is Brendan Leiden. And I would like to reserve 5 minutes for rebuttal argument.
Thank you very much. Justice McDonald will be our timekeeper, and he will hold up signs of 5 minutes and less.
Thank you. Thank you, Your Honor. Under the plain language of the Connecticut Product Liability Act, a hospital can be a product seller. There is no exclusion and there is no exemption for hospitals or any kind of healthcare provider. Now, hospitals, when they buy and resell to their patients the implantable medical devices, they can easily seek indemnification from the manufacturer if that medical device happens to be defective and harms their patients. Yes, Your Honor.
Counsel, does the hospital market the medical device that way? The way I normally think of a seller marketing a product.
The market, they can market, yes, Your Honor, in a couple of different ways. And in this particular case, Bristol Hospital was marketing the mesh sling on its website. That's one way. And then the other way is they market through the physicians who are actually their agents, you know, either whether they're independent or employees of the hospital. And mostly it occurs through the physician who markets it to the patient and convinces the patient to undergo the surgery. So they can market it, and they do market it in a variety of ways.
And was it marketed in this particular case to the individual?
Yes, it was marketed in both ways.
Hospital?
Yes, it was marketed in both ways on the website, and it's in plaintiff's, the web page, I believe, Your Honor, would be A115, which shows the web page where Bristol Hospital is actually marketing the device. And what the hospital also did in this case.
Hang on.
I'm sorry.
And your client looked at that marketing?
She did not look at the marketing, Your Honor. However, whether or not she saw the marketing would be irrelevant to whether the hospital is a product seller. Okay, so that might go to a causation issue, but for the issue presented here, whether the hospital can be a product seller and is in this case, whether the plaintiff saw that particular marketing or not, they would say is irrelevant, because what happened here, mostly the marketing was done through the physician, through Dr. Breakstone, who has privileges at the hospital, was likely given special privileges, may or may not have been, it depends sometimes, for these pelvic mesh products, and specifically marketed it to Mrs. Normandy as, you have to have this, this is the only treatment you can have. So that's the predominant part of the marketing that occurs here is through the physician.
Okay, I may have some more questions, but I'm going to hand it over to Justice Mullins for now. Thank you.
Okay.
Thank you, Chief. I just wanted to get clarification, mainly on some of the questions that Chief asked. You said that the hospital marketed this through on their own, not just through Dr. Breakstone?
Yes, Your Honor. They have a web page and they have websites, and it's framed as patient education, but they specifically mention the mesh slings or synthetic slings is, I believe, the way they mention it. And they also market the physicians on their website, and plaintiffs included those web pages as evidence that they had Dr. Breakstone on their site. And this was a little bit confusing, a little bit tough to follow, I believe, at the trial level, but the web page for Dr. Breakstone, for the hospital had Dr. Breakstone, and then you go to her practice website, and then through her website, I specifically found marketing for the Monarch sling, which is the sling at issue in this case.
Is there, just a couple of questions, and I see other people have them. So I thought the trial court made a finding that they didn't market the product on their site, and there was nothing to support that you could impute Dr. Breakstone's marketing on her site to the hospital. Do you want to comment on that? Is that not accurate?
It's plaintiff's position that is not accurate given the documentary evidence, and it would be, I did not write down those pages, I don't think. Well, it would be around A115. I believe the marketing, the doctor's web pages were after. And if I recall correctly, the trial court wasn't sure, I guess, of the veracity necessarily of maybe the web pages, and didn't get to point to her at the time. If you look at the bottom of the page, it gives the address, the web page address. So if you trace them through, starting on at the bottom of A115, you see that was by Bristol Hospital. And then I apologize, the web pages are actually around A230 is Dr. Breakstone's web page. Yes, A230.
Counsel, if you finish answering that question, Justice McDonald, myself, Justice Kahn, and Justice Ecker have questions.
Could I just
Okay.
one follow-up?
Sure.
What would be the basis for holding the hospital to have marketed the product through Dr. Breakstone's website? Why would Dr. Breakstone's website be attributable to the hospital?
Because the hospital is marketing Dr. Breakstone. So if you're from the patient's perspective, you're looking at your doctor. Bristol Hospital has Dr. Breakstone there. Say, oh, let me find out about her. You're going to go to her webpage, and on her webpage, at the bottom, at the very end, on A234, she specifically mentions the Monarch sling. So physicians are agents of the hospital, whether or not they're independent contractors or employees. They have to have privileges at the hospital. And the patient has to go to that hospital where the doctor has privileges. So the hospitals are part of this whole marketing scheme. And then also the manufacturers market to both the hospitals and the doctors to get these products to market, and implant it into patients.
Okay, thank you.
Justice McDonald.
Thank you. That kind of segues into my question. I just don't have the opportunity to dig through the appendix as much as I would have liked. Is there any suggestion in this record that this was like the good old days where the manufacturer hosted seminars where the doctors were brought in and the hospital representatives were brought in an effort to get them to use their medical devices?
That's part of the allegations in the complaint, Your Honor. And for this case, this was developed just for the product seller purposes, but we do know from plaintiff's counsel has done many other pelvic mesh cases in Connecticut. The manufacturers do conduct this kind of activity, but there was no specific evidence in this case that any of that occurred. But there is a general marketing scheme as alleged for hospitals, doctors that do come into the hospitals and do things of that nature.
And I since we'll have a transcript of this, I should note for the record my sarcastic use of the good old days but thank you, counsel.
Well, I understood, Your Honor. My husband's a physician, so I understand what you mean by that.
Counsel, I have a question, and then it'll be Justice Kahn, Justice Ecker, and Justice Keller. I think we're going to have a hot bench on this one. You mentioned earlier that they were marketing, but you also mentioned educational purposes on the web. Are those two issues teased apart? Do we know what's educational and what's marketing?
They are not, Your Honor. But either way, I think both apply to marketing. It's framed as education. Just the fact that they do put it out there on their website.
No, but in an educational purpose, I guess they could be the same, but I'm sitting here thinking about it, and an educational purpose is entirely different from marketing purpose. I mean, you want your patients to know what the procedure is going to be like and who is going to do the procedure, things of that nature. That seems to be educational. If you're trying to sell a product and market a product, that's a different thing, or it seems to be different to me. Am I wrong?
Well, Your Honor, I would respectfully disagree to the extent that they're intertwined with each other. You can't market your product unless you educate the patient or the consumer about the product. So education
so
about the
was. Yeah, I'm just trying to think what the purpose of the marketing.
The purpose of the marketing is to get the women to trust the device so that the doctor can implant it and the hospital can sell it.
But I thought you argued that the hospital marketed the doctor, and it was the doctor who marketed the sling. That, to me, is rather tenuous to say that the hospital marketed the sling.
Well, the hospital did both. They on their webpage, they market synthetic slings, and through their doctor, they market all slings, because what the hospital has stocked on their shelves is not just one sling. They have a variety of slings, or other pelvic mesh products for pelvic organ prolapse. So they use predominantly the doctor, because the doctor is a little closer to the patient, but for the general public purposes, because after the doctor tells the patient might go to the website and want to learn more about it. Patients may do that. And if they do that, they'll go to the hospital and they'll find this information about the sling and say, oh, okay, here the hospital's advocating it, they're marketing, or they're saying it's okay, they're saying it's safe.
Okay.
It must be okay.
Thank you. You've answered my question. I'm going to try to turn it over to others so they can ask their questions. Justice Kahn?
Thank you, Chief Justice Robinson. So I have 3 questions to ask so that I can then yield to my colleagues as well. Trying to understand your marketing, you cited to page A242 and A240, which is basically the physician directory for Bristol Hospital. So it's
A232.
A240 to A242. And the particular doctor, Drake Stone.
It was A232, Your Honor, I believe.
A32. Okay. So you
232 to 234. Yes,
okay.
A234, which is where the monofs.
Which is their group, but you also attach the physician's directory. So is it part of your position that by listing their attending physicians in a physician directory, that's marketing them?
Yes, Your Honor, I would. If it's online, it's definitely marketing. It's not a private.
And then you cited A115, which appears to be talking about health and wellness resources and different kinds of procedures. And they talk about the sling procedures. And you said it's informational, but they're marketing a product to reassure patients of its safety, you just said in response to the chief's question. But I'm looking at A115, and at the very bottom, when they describe the different sling procedures, it says, the FDA has reported complications associated with some synthetic mesh slings. Is that an effort to reassure, to market something as safe, or is that the opposite, to inform patients that there are complications to the mesh? Doesn't that kind of counter your argument that this was to reassure patients it's safe, when that very page ends with there are complications associated, reported by the FDA?
Well, I'm not really sure. I can go to the intent of the hospital. That was a factual. Well, let me back up a minute. This web page was from 2016. I don't know if this was there in 2009. Look at the FDA public health notifications. The first one came out in 2008.
Okay.
And it described complications from.
So I get your point. Maybe they didn't know in 2009 and they knew in 2016, but then shouldn't we be looking at what they marketed in 2009, not what they're marketing now?
Yes, Your Honor. Unfortunately, that was not available. And likely that's why the predominant way is really through the physician, and that they do still continue to market in 2016.
That's what you're relying on. Let me get to my two questions, because I know my colleagues have questions to ask. The second question is just very simple. I'm trying to understand if you are claiming, I don't believe you're claiming that there were factual, other than whether the hospital's in the business of selling meshes or slings, that you're not disputing that there are any factual questions, issues open that would make summary judgment inappropriate, other than just applying the known stipulated to facts to the definition of being in the business of selling something, correct? Or are there factual issues that you think exist that would have made summary judgment inappropriate?
Well, I think within the record, I think there were a lot of facts that would have made summary judgment inappropriate. Such as starting with, if we look at the affidavit of Bristol Hospital's corporate representative, Corinne Roth, and we look at her testimony on cross-examination, it's contradictory. Okay, so Bristol Hospital says they don't market, and then she actually admitted that they do market and promote mesh. So that creates a question of fact as to which is accurate and credibility. And then you look at her affidavit that describes the process of how the mesh is purchased, and hospital claims that, well, we don't keep it or stock it on our shelves. When the doctor calls us, we call the manufacturer, and they send us that particular product for that one surgery. And plaintiff's evidence, the email between Bristol Hospital, AMS, and Dr. Breakstone contradicts that evidence. It shows that Bristol Hospital purchases the mesh products and keeps a par level of 2. Okay. And then plus we have the stipulation from counsel. We had other evidence. There's an AMS document that shows the regular sales, and counsel stipulated that there were regular and ongoing sales for at least 3 years at a substantial markup. So those facts alone create a genuine issue of material fact, because that's, the predominance of the evidence set, put in by Bristol Hospital.
Okay. And my final, thank you. My final question is this. It's a hypothetical. Hospitals use towels. They use gauze. They use test tubes. They use suturing tools. So are you saying, like, where should the line be drawn? If I go to the hospital because I have a cut and they're treating the cut and they use sutures, or now they use crazy glue, literally, to seal cuts, and something's wrong with that product, does that mean the hospital is in the market of selling sutures and glue and paper towels and test tubes and tubes used for blood drawing and needles used for blood drawing. Where is the line drawn then?
So first, for your honor, this is an implantable permanent medical device. So that's one line that can be drawn there. And the other way that the plaintiffs believe the line can be drawn is if we just march through the analysis. We start with, under the plain language of the CPLA, a hospital can be a product seller as they are a distributor of these implantable medical devices. Now, the FDA regulations, which we address, define distributor as anyone who furthers the marketing of the device from the manufacturer to the end user. That's what the hospital does. And so then we march through, well, what's the involvement in actually getting the product into the stream of commerce? So Bristol Hospital, they have a committee. It's either a VAT committee, the value analysis committee, or a committee by any other name, where they specifically research and investigate the device. And they look at it and what plaintiffs' evidence show, the testimony, excuse me, from Mr. Phil Cooney, I pulled that one out, said that they base their purchase of the medical devices solely on the contract price. They have the sole control over whether or not the hospital uses that product. The doctor does not have any control over that. The doctor can request it, but it must be approved by the hospital. And if we look at the basic product liability law in determining a product seller, going back to either Burkert, the Petrol Plus of Naugatuck, and then the Svedri Mercedes-Benz Credit Corporation that we cite in our briefing, it gives the criteria. And one of the main criteria is substantial involvement in the stream of commerce, taking title to the product. It's very, very important because Bristol Hospital took title here, and they had substantial involvement in bringing this product to market. If they said, no, we're not selling it here, then it's not sold.
Well, that concludes my questions. I do want to yield to my colleagues and of course, return back to the Chief Justice. Thank you.
Thank you. The order will be Justice Ecker, Justice Keller, Justice Daria.
Thank you, Chief Counsel. Just very quick factual question. I saw some reference to the doctor being a staff physician, but then that didn't seem to be emphasized. Is she an attending doctor with privileges, or was she actually an employee of the hospital?
It's our understanding she was just an attending. I don't have evidence to the contrary.
Okay. All right. Fair enough. I just wanted to straighten that out. I'm struggling with one of the things I'm struggling with is the question of, of to the extent to which this is a sort of a policy question for the court to decide whether hospitals should be within or outside of the Product Liability Act, and to what extent it's a jury question. The statute defines product seller. And so is it a jury question? I guess my first question is whether Bristol Hospital was in the business of selling the mesh among whatever else it did, in the same way that a movie theater is in the business of selling popcorn, even though that's not its purpose in existence. Is it a jury question to decide on the Burkert factors?
Well, it is plaintiff's position, yes, Your Honor, that is the case. However, there's conflicting law that whether an entity is a product seller is a question of law for the court, so it is somewhat confusing. But
one thing that struck. Go ahead. I'm sorry. I didn't mean to cut you off. Go ahead.
I was just going to say, Your Honor, in some cases where it's very clear, where you look at Burkert, and it was very clear as a trademark licensor, they had absolutely no involvement in the stream of commerce. So that might be an easy case for the court to decide as a matter of law. But when there are so many conflicting facts, material facts that there are in this case, it really should be a question of fact for the jury.
Now, is one of the facts I'm trying to get this straight? I mean, it would seem to me to matter a lot whether the business entity is getting a economic benefit, and I know that's one of the Burkert factors. Was there evidence here? You said that they upcharged from $900 to about 400%. Now, I would think that if a business is doubling or tripling or quadrupling its margins, then that's an indication that it's in the business of selling the product. Am I correct about that evidence?
Yes, Your Honor.
Could a jury have found that?
Yes, Your Honor, absolutely. That is one main factor, but it's not the only factor that's involved. It's in the business on a regular basis, which was stipulated to by.
If I go to a car, I want to get my car serviced. I'm not there to buy. I'm not, or I'm there to get my car serviced, and they put in some ignition device or something in the process, and it blows up or is defective or disintegrates or causes injury. Is it clear that car under the law? Is it clear that car service is a product seller for purposes of the Product Liability Act or not? Assuming they charge for the item and mark it up.
So interesting. I think that brings us to the Truly v. Hayes issue of participation, or the principal part of the transaction not being the furnishing of professional skill or services. So that hybrid transaction you talk about, I think we have to back up before we look at the actual transaction and go through the criteria of, are they a product seller under the law? So if it's a car dealership, they're in the business of selling cars, and part of their business would be selling parts. There's a parts department usually that I've seen when I go to the car dealership. So it's kind of an easy analysis. Well, you're in the business of selling parts, but if you meet the other criteria first, and then you look at that transaction, you may not even need the principal part of the transaction. And one of the things with this is, I don't think this court has actually adopted that hybrid transaction or principal part of the transaction policy in order to determine it, because that gets very subjective.
I'll pass to others. We could talk all afternoon, so I'll let my colleagues ask questions.
Thank you, Justice Ecker. Justice Keller.
Thank you, Chief Justice Robinson. I just have a few questions for you, Attorney Fusco. Number one, does the hospital admit that Dr. Breakstone was their agent?
I believe they. I'm not sure, Your Honor. I'm not sure that was actually addressed.
You call her the agent, but I'm just wondering whether they've conceded that fact. Number two, didn't the Burkert case decide that whether the defendant is a product seller under CPLA is a question of law for the court, not the jury to decide?
Yes, Your Honor. Absolutely.
So you want us to overrule that and say, let the jury decide whether or not the hospital was a product seller?
I would not say overrule. I would say distinguish, Your Honor, because in that case, it was quite clear that GM was not a seller because they had involved in a trademark license. An issue of fact would be more consistent with the summary judgment standard when there's a genuine issue of material fact, that the judge is through numerous facts and factual discrepancies. And so the fundamental function of the jury to determine the credibility, the witness, and the evidence. And that was taken away in this case because of the discrepancies of fact.
All right, and I'm looking for the name of the case. I think it's Farrell versus Johnson & Johnson. Am I correct? The one that involved an innocent misrepresentation claim against a doctor with respect to a similar kind of sling. Is that right?
Yes. Yes, Your Honor.
Doesn't that case significantly help your opponent, because it talks about the provision of professional services is not a commercial transaction, and a tort based on principles of warranty, which arguably the CPLA is. It's kind of a strict liability to get around having to prove all those other kinds of torts like breach of implied warranty, etc., can't be based on statements or it can't be based on the performance of professional services. Does that help your opponent, that case?
Actually, I believe it does not, Your Honor, because that case, that was a doctor, and the doctor's not the product seller. There was no allegation that the doctor was the product seller. So plaintiff's position is hospital sells the product as a product seller, the doctor provides the service. All right. There was no allegation that Dr. Hines bought and resold the product. However, if Dr. Hines stocked the pelvic mesh in his back room, all right, and then as the patients came in, he sold them at a profit on a regular basis, yes, he would be a product seller under the standards of product seller. Doesn't matter that he's a doctor, they can certainly be in the side business as a hospital is of selling products.
Okay, one last question. On A234, you say Dr. Breakstone marketed the Monarch sling. All I see on that page is Monarch underlined.
Monarch. That's the Monarch.
Underlined, but it doesn't say what it is. It just says additional information, Monarch. How is that a marketing ploy?
When you click on that link, you go to the,
Okay.
it doesn't exist anymore.
You
It
didn't
was the
give us
Monarch.
that in the appendix. You didn't show us in the appendix what happens when you click on the link, right? Probably not. Okay, that's
I
all
don't
right.
think I
Thank
did.
you.
Okay. Thank you, Your Honor. I see my time is up.
Hang on, counsel. Sort of an interesting dilemma. We do have a rather hot bench, and there's two other justices that want to ask questions. I think you're actually going to go long because of a time calculation mistake that we made. So you're going to actually have to be 35 minutes, and I'm going to give the other side at least at 5 minutes. But I think in order to get the justices in a place where they can receive answers to their questions and feel that they have sufficient information, I'm going to let the question continue, and then I'll add more time to the other side as necessary. So, Justice Daria.
Chief, I would hold this for rebuttal, except I want to be kind of change the subject a little bit here. Charge, which is kind of impressive. It's a fairly. I guess my question for you is, the cost was billed at zero. If your case.
Chief, I'm not sure. If
Sorry, you're
everybody else is
breaking
having
up.
this issue.
Yeah, I'm not
Apparently
getting
here,
that
this is
audio.
Dorian.
You're breaking up.
Is this any? I'll try
You're freezing.
again. I'll pass, Chief.
Why don't you try this? Turn your video off and see if you can ask the question that way. Maybe it's a bandwidth issue.
Okay. All right, let's try.
No,
Chief, I'll pass.
still gone.
Okay.
Thank you. Maybe we can reboot between counsel. Justice McDonald, you have another question?
That's fine. Go ahead.
No, Chief, I don't.
Justice Ecker?
I just forgot to lower my hand. I don't have any other questions. Sorry about that.
Justice Daria, could you just try it one more time before we switch?
Yeah, sure. Can you hear me a little better or no?
Yes, for now. No,
Sorry about that. My question is, if the cost was broken out as a zero, is your case weaker in avoiding summary judgment?
okay.
Going to the
Let me try to
jury,
repeat the
maybe
question.
accounting.
Let me see if I can repeat the question for you, Justice Daria. If the cost was zero, does that make your case weaker for the issue of summary judgment? Is that, Justice Daria?
It may, Your Honor, but if there are all the other factors involved, and this brings me back to the whole intent of the CPLA. I guess I didn't really get to it, but the intent of the Product Liability Act, two parts of it I think are relevant here, is that the risk prevention should be placed on those parties who are most able to achieve that goal of risk prevention. Another intent is to prevent harm from defective and dangerous products or hazardous products, from harming people. And the hospital is in the best, if not only, position to really protect the patients from harm, because if we look at the federal regulations,
that would be true. And if then that's fine, just pass me. But if that would be,
I'm not getting any of that.
True zero, that they would best protect it.
I did not get that.
Mrs. Daria, we're not getting it. Why don't you try to reboot before Mr. Riggs starts to argue? So why don't we just take a 2-minute in-place recess while Justice Daria reboots his Teams program.
Chief, just because of that additional time,
You can go ahead.
Chief, you're mute.
Yes, the other option is if it gets worse, Justice Daria is to use the call-in feature. If everything goes, it's getting really bad. Counsel, thank you very much. You have your rebuttal time. Attorney Rigg.
Thank you, if it pleases the court. My name is Michael Rigg, and I represent the defendant, Bristol Hospital. Just wanted to address the claim of marketing. The web page that was submitted to the trial court, the Bristol Hospital web page, doesn't really constitute marketing of anything, but to the extent that there's a claim that this is marketing, it's marketing of a service, of medical services. It's talking about surgery and sling procedures. And that was the testimony that was provided by Corey Roth, was that, yes, there was some marketing, but it was marketing not of any product, but of medical services. Yes.
Justice Eckert and Justice Keller.
So I just struggle, counsel, with the services products distinction. I know, just because so many businesses, including hospitals, do both. The car example, you could name countless examples where there is a sale of a product that's inherent part of a business. A hospital could be a kidney, it could be an implant, it could be something much more peripheral along the lines of the screws in that case, the pedicle screws. It could be any number of things, and it's just troubling to develop a doctrine to me that relies on sort of a case by case analysis of which it is and which it isn't. So one question I have is just whether you can help on that, developing some kind of a legal rule that would be a little clear or more objective than in any particular case. I also wanted to ask you if you could comment on I mean, it does seem to me if you mark up the price a lot, that it's a strong indication you're selling the product, even if that's not your main way of making money, and then the other question I had for you, I'm throwing them all at once, I don't know why, but is just this, well, it just seems to me there's a question in my mind about whether the policy making would occur if this court does find the hospitals to be included, or if we say, they're not included. I mean, the legislature should be the one to make that decision, it seems to me. We're dealing with the statute we have, but your opponent does point out that the legislature, at least according to them, the plaintiff deliberately did not adopt the version of the draft Uniform Act, which would have accepted providers of professional services, and that's very significant if it's correct to me. Could you comment on those, I guess, 3 points?
Yes, Your Honor. Just I'll start with your last one. So I think it's already been resolved in terms of the sale service distinction by this court, and that's the Zakiki decision, which is that the Supreme Court, this court has already said that there is this distinction, and again in Farrell, that's what this court. Although Farrell itself was not a products liability claim, it was a strict liability claim. And because Dr. Hines was deemed to not be primarily.
Is it a workable distinction, counsel?
Well, I'll point, Your Honor, to some legal authority that did not accept it, which is the New Mexico Supreme Court. And it's a case that I do cite, but not for that proposition. And it's called Parker versus St. Vincent Hospital, that appears on page 23 of my brief. And that case provides a long discussion where the court did not agree. It sort of adopted the concerns that Your Honor had, and held as a matter of public policy that hospitals should not be sued or liable for products liability because of the detrimental effect that would have on healthcare. Because in particular, if you force hospitals to sue manufacturers for indemnification, what that will mean is that hospitals will choose large corporations that can bear the financial cost, and that will limit innovation in medical products and innovations, so that the smaller companies won't be able to bring their products to market. So that was what the New Mexico Supreme Court held. Now, frankly, that case is an outlier. Every other case in the country has ruled that has followed the sales service distinction.
And what about the distinction between these two model acts? Could you comment on that? And then the markup issue.
Well, first of all, it's been established under, I think there's this argument that based on a prior decision by this court that this court did not adopt the more recent restatement of products liability, but under the prior restatement, it had been well established for many years that hospitals, because they were in the business of providing services, could not be sued for strict liability. And this is not a statutory cause of action.
No, I'm referring specifically to the point on page 17 of plaintiff's brief, where they say that there's a draft Uniform Act that excluded professional service providers, and we didn't adopt it. We adopted a different one without that exclusion. Is that true?
I think that particular language was not adopted, Your Honor, but I think that had to do more with the blood shield. My recollection is it had to do with the sale of blood products, and Zakiki, it's decided it that this court would have to overrule the Zakiki case to reach that, to say that the statute doesn't make this distinction between service and the sales service distinction. And this court's already established back in the 1980s that that's what Connecticut law is. And it's important to keep in mind that the products, that it is a common law. It's a development of common law, and that the legislature simply codified as a matter of convenience the common law. And this court has consistently developed the products liability law as a matter of common law.
What about the markup issue, sir? I'm just trying to hurry so other people can ask questions. What about the markup? I mean, either you marked it up or you didn't. I'm not asking whether you got paid. I'm asking, I'm not as familiar with the appendix as I should be. So please just tell me what the information is available about that question.
Yeah, so I had agreed to a stipulation that there was at least a genuine issue of material fact, that there was a 200% markup. So that was a stipulation on the record.
Isn't that a pretty strong indication that you were selling the product? I mean, what else conclusion is possible? What other conclusion is possible?
The issue is whether we're in the business of selling products as opposed to the business of providing services. So, for example, the case law establishes, let's say somebody I own a car and I decide to sell it, and I sell my used car instead of to somebody. I'm not in the business of selling cars. I can't be sued under the products liability statute. You have to be, and that's the plain language of the statute as well, Your Honor. You have to actually be in the business of selling products, not that there was a sale of a product. That's not enough. You have to be in the business. And so it matters really from the perspective of the plaintiff. Why did the plaintiff go to the defendant? Did the plaintiff perceive it as a purchase of just purchasing a product? And the answer in this case is no. The plaintiff testified in her deposition and said in her affidavit, the reason I went to Bristol Hospital was for a surgery. Now, the plaintiffs are arguing, oh, well, that's not really the case, that the hospital has nothing to do with the surgery. That's really quite an argument, because that would, I guess, mean that hospitals are not in the business of providing medical care and therefore can't be sued for medical malpractice because they don't provide medical care to people. I mean, that's in effect what the plaintiff is arguing here, that people don't look to hospitals for medical care. And that's contrary to the record here and also contrary to the law in Connecticut. And this court even adopted the apparent agency doctrine based on the presumption that, yes, people actually do look to hospitals for medical care. That is the relationship between the public and hospitals. Now, I'm not advocating that a hospital could never be held liable under the products liability statute. For example, if somebody goes to the cafeteria and purchases food, well, yes, that would be the sale of a product. And in fact, the products liability law originated in the area of the sales of food. So yes, that would be an example where a hospital could be held liable. But when it involves its core function, which is to provide medical services, it's a service. So it doesn't matter that there's a markup. What matters is, what is the relationship between the plaintiff and the defendant? So for example, in the appellate court decision in Truglia, that involved a claim that they sold a sidewalk, but the appellate court held no, they brought the concrete and constructed the sidewalk. There was no discussion as to, well, how much did they charge the municipality for the concrete? Obviously, they had to buy it and bill it back. Was there a markup? And of course, in the Zabros case, the court held the markup was irrelevant, because the issue is, what is the relationship between the plaintiff and the defendant? Is it that of simply a sale of a product, or did the plaintiff go there for the purpose of receiving a service. So Your Honor had talked about an auto mechanic. Well, if you went to the auto mechanic and said, I just want some tires put on the car, well, then I think that would be the sale of a product. But if you went there, I don't know what's wrong with the car, fix it. Well, that sounds more like a service. So it matters why you're there. And that's what every court, frankly, in America has focused on, other than the New Mexico Supreme Court. And they said for different reasons that they weren't going to allow a hospital to be held strictly liable for public policy reasons. That's the only court that I know of that has done it that way. Every other, and I think it is significant that the plaintiff is asking that this be the first court in America to do this. And the evidence is the word monarch appears on Dr. Breakstone's website that was never seen.
Other people, counsel, other people have their hand up, and so you've answered my question. Thank you very, very much.
Okay, I'm just going to pick an order here. Justice McDonald, Justice Kahn, then Justice Keller.
Okay, I'll be quick. To follow up on that, why does it have to be one or the other? Could the hospital not be in both the business of providing medical services and in the business of selling products? And let me just, as you're thinking about that answer, I'm just drawing an analogy to in the practice of corporate law, right? Corporate lawyers draft legal documents, offering statements, etc. But they also provide strategic corporate advice about who to put on a board of directors or which venture capitalist is the best one to try to get money from. Are they practicing law when they're giving strategic corporate advice? Or could they be doing both, giving corporate management advice and also practicing law? So why isn't that distinction the same in this context?
Well, because it's because the issue here is whether strict liability is going to be imposed, and I don't believe that in the area of corporate law is whether or not there'll be strict liability. The entire premise for imposing strict liability is that those who engage in the business of selling products accept that, and that because that's what they're doing, and because they're for example, they're marketing themselves, the public is coming to them, and it's the vulnerable public. That's the justification for the strict liability. And this is a situation in which the plaintiff freely admits that she did not go to Bristol Hospital to buy a product. In fact, it was her health insurance that was billed for it. She didn't. I think that is also highly significant. If you yourself are not even paying for it because it's covered by your health insurance, which frankly covers a service, medical service.
But if it's at least plausible that they were in both businesses, why is that not a question for the jury?
Well, again, the question is, what were they primarily doing? What was the essence of the transaction? And so, yes, it is possible, but we're not asking for the court to say a hospital could never, ever be held strictly liable. In fact, this court, in a footnote in the Farrell case, made the same observation, was that in that particular case, but because of the evidence and the allegations, it was clear that Dr. Hines was not primarily.
Isn't that a judgment call of which one was the primary one? Why isn't that for a fact finder to make that determination rather than a question of law?
Well, because of the uncontroverted testimony and the evidence here is because the plaintiff didn't see any of this alleged marketing, number one. She went to the hospital because her doctor said that's where the surgery is going to be. She had the discussion with her doctor about what to do, and her doctor provided this service. I mean, the plaintiff on the one hand is saying that Dr. Breakstone is our agent and we're liable that way. Well, then why wouldn't this case fall squarely within Farrell? Because if Dr. Hines was not primary, Again, this is the same exact product as in the Farrell case, the same product and the same procedure at issue in the Farrell case as in this case, and the same plaintiff's law firm. So so if Dr. Hines was not primarily engaged in the business of selling the pelvic mesh, then how could Bristol Hospital be vicariously liable for Dr. Breakstone, who it's admitted that was the only reason why the plaintiff went to Bristol Hospital and went to Dr. Breakstone. I mean, in that respect, the Farrell case is on all fours here. And because the test that this court applied in Farrell is identical to the test that is used in all products liability cases, where it's whether or not. So there has to be a determination as to whether the defendant is primarily engaged in that business, not as some kind of side thing, or at least that the transaction itself, that was the primary focus of the transaction.
Thank you.
Yeah.
Justice Khan?
Thank you, Chief Justice Robinson. I have two questions, counsel, and one relates to this issue of, I asked your opponent, where do we draw the line? Our sutures, our paper towels, other supplies and other things that hospitals use in the provision of providing treatment or care in the service, would those be included? And you seem to be answering the question in two ways. You seem to be saying, well, if it's food at the hospital cafeteria, then they're clearly selling food. I imagine that would be the same with a gift shop. If you buy a gift for someone who's having a baby and the gift is defective, they could be subject under the CPLA. But let me give you a different hypothetical, because you seem to say, well, we're not saying that, and the Farrell case doesn't say that it can never happen that a hospital is liable. A lot of hospitals have committees that basically review either new drugs, so they have one for pharmacy, they have one for perhaps other things that a hospital is going to allow. So they have to approve all the drugs that are used, that the pharmacy dispenses. Let's assume you have a situation where, and I know that physicians sit on those committees, and a physician, the committee reviews a submission to allow, because whether it's the orthopedics or the cardiologist, they now want to use a new drug, and they go to I think it's called the IEP committee or pharmacology committee of the hospital, and they request and get approval from that committee that reviews the data and scientific data to approve that particular use of that product. Would that be different now? Because now the hospital is functioning as, if you will, a gatekeeper, authorizing or not authorizing, approving or not approving a new drug. Would that be a situation where the hospital would now have liability?
It could be liable under a theory of malpractice. I mean, a hospital could certainly be held liable.
Well, you could always be liable for malpractice because you made that wrong decision. But when you're involved to that degree, would that now raise liability under CPLA?
I don't believe so. In fact, that's what makes a hospital very distinct from, say, a store. I mean, they don't do that. Stores that are in over at the Stop and Shop, they don't have a committee that determines whether they're going to sell Tylenol. And so that's actually, I think, what distinguishes hospitals from what would be a traditional product seller, is that they have to do this because of the relationship between a hospital and a patient. This is a professional patient relationship. And that's why they use licensed physicians to make these determinations.
Did that happen here? In terms of not this particular mesh, but any other type of mesh, was that ever done, did that ever go through a committee of the hospital that you're aware of for approval?
Yes.
It did. Okay.
Yes. Yeah. And it was called there was some evidence in here about
Okay.
the committee. And I don't think that helped the plaintiff's case at all. Also, this claim that, well, the hospital stocks medical supplies, as if, somebody showing up in an emergency department, oh, well, you need stitches, so I guess we should order some. Yes, they're going to stock medical supplies. That's right. That's what hospitals do. In fact, I think they could be sued for malpractice if they didn't stock medical supplies. That's what they do. That's the service they provide. That's why people go to hospitals. They go there for medical care. They don't go to Stop and Shop for medical care.
Let me ask my final question so that my colleagues can get their questions in as well. My final question is, would you care to respond to your opponent's response to my question about, do they claim there are issues of fact that would preclude summary judgment? I know that there was an exchange with your opponent and Justice Keller about the Berger case and the fact that this is whether the hospital's in the business of selling a product or providing a service is a question of law for the jury, and there have been some questions to you on that. That aside, would you care to respond to your opponent's claim that there were issues of fact that would have precluded summary judgment? And do you agree?
No. Right. No. I mean, first of all, determining what fact is a material fact is always a question of law. So, again, if the evidence is clear, and normally, and what the case law has said is that they may not be deciding these on a motion to strike or a motion to dismiss. There has to be a factual record that's developed, and it is a fact-specific inquiry. But this court has noted, just because an inquiry is fact-specific doesn't mean that it doesn't present a question of law. Yes, it is fact-specific, but it's still ultimately a legal question as to whether somebody is primarily engaged in the business of selling a product.
Do you disagree with her representation about two contradictory affidavits where one person admits they're selling something that the hospital's in the business of sale and then later says not?
Oh, absolutely. Yeah. Yes, absolutely. That's incorrect, what was said. And that has to do with deposition testimony of Corinne Roth. And it had to do with, the claim is that Ms. Roth had admitted to marketing products. No, she did not. She admitted to marketing services because she was being asked about the web page, and she was talking, and she said, yes, that's marketing of services, of what we do. And it's just based on the printed language in the web page that and printed materials do present a question of law as well.
Thank you, Counsel. Chief, I thank you and return back to you.
Justice Keller.
Thank you, Chief Justice. Attorney Rigg, I had a question about these committees that the hospitals have, the VAT committee in this case, and the committee that Justice Kahn was talking about. And you kind of touched on my question. Hospitals are regulated by the state and also by the federal government, correct?
Yes.
All right. And are they required to have certain equipment, devices, and scalpels and things like that by state regulation or federal regulation to have these things on hand?
Yes. Yes,
they are.
They have to.
And are they required to have these VAT committee type things by state regulation?
I'm not certain, Your Honor. I know that it is it's certainly statewide. I think they do, but I'd have to research if
so
there's.
To me, that really takes it out of the notion that they're in the business of selling things when they're regulated and told they have to have these things on hand. And I think Would you agree with me that it really boils down to the primary purpose test that was talked about in the district court case you cite, MyHawk?
Yes.
Versus Meltronic, which cited a Superior Court case called Lambert versus Charlotte Hungerford. That was where the surgeon used pedestal rods during a spinal fusion. They tried to sue the surgeon for the defective rods, and the distinction is the primary purpose was the service of surgery. And here, don't we have the same thing? We have a mesh used to contribute to the primary service, which was to fix the plaintiff's bladder issues. Is that correct?
That's correct, Your Honor. That's the legal test that all courts, including this court, applies. That, to go back to the question, is where do we draw the line? That's the line. That's the line that this court has drawn in the Farrell case, and it's the line that every other court in America, with the exception of that New Mexico decision, have drawn.
My one quick question: do you concede that Dr. Breakstone is the hospital's agent?
No. In fact, that wasn't even argued at the trial level, that we were somehow liable for marketing by Dr. Breakstone. I also do cite the Connecticut general statutes, which actually define what a hospital is. And that definition of what a hospital is cannot possibly include the fact that the hospital is engaged in the business of selling products. A hospital, in order to exist, a hospital must provide medical services. Otherwise, it won't be a hospital. Now, again, there could be ancillary things that they do, such as they have a cafeteria. Okay, but that doesn't involve the professional-patient relationship. But when it gets into the core of what a hospital could be sued for, let's say under a theory of medical malpractice, that would by definition mean that they're not the transaction doesn't involve the sale of a product primarily, I should say. Yes, I mean, the Zabras case said, yes, you can provide a surgery and bill the patient for the products used in the surgery and still not be in the business, even if there's a markup. That was the issue in the Zabras case, was that the plaintiff was arguing that the affidavits were misleading because there had been a markup.
I believe there's a question from Justice Ecker. You're muted, Justice Ecker, you're muted.
Maybe nobody else is having this problem, so it just may be mine, but I'm still struggling with this primary purpose test and how just remarkably mushy it seems to me to be. Let me give you some hypotheticals and tell me, and more, I think these will become relevant, which is maybe another reason we need legislative guidance here. But I go in the hospital for a new hip, artificial hip. I go in for a heart, artificial organ. I'm going there for the product. Now, you could say, well, actually, you're going there to have the, implant, the installation of the product. It's really a service. And we could argue till the cows come home, and it's just a matter really of semantics. So what about that line? Where do you draw it? I mean, maybe she said, maybe this particular person said, look, I'm going in because of this medical problem. But she could just easily have said, look, I'm looking for a mesh. I've done a little research. I need a mesh installed. Will you do that? So would the outcome be different?
No, I don't think so, Your Honor, because let's say the hip replacement, that's a good example, a good question, but it's not as if a plaintiff can't sue under the Products Liability Act. They just can't sue the hospital. They can sue the manufacturer. It's not as if there's no remedy.
Why can't you sue? That's the question: is why can't you sue? Why can't you sue the hospital? I mean, you mentioned earlier the purpose of the strict liability. The purpose of strict liability, as I understand it, is a cost spreading mechanism. And who's in the best position to spread the cost but the hospital, right? To internalize externalities. Who should pay? Well, and maybe that's the manufacturer, maybe it's the hospital, but it certainly is consistent. Let me put it this way. It's consistent with with the fundamental driving, animating purpose of strict liability law in terms of cost spreading to make the seller of the product, the one who gets paid for it and charges for it, liable, isn't it?
No, I don't think so, Your Honor, for what I had explained before. And I think on that particular question, I think the Parker decision is highly persuasive as to why that's not good public policy and that hospitals are not in a good position to bear that cost. And that's because
they're in a good position to spread it, aren't they? I mean, they're the ones who bill the insurance company. And the idea would be that if there's costs that are imposed on the users of the product, like, for example, failures of the product that create additional cost. That's why cigarettes cost $10 a pack. Mm-hmm. You try to get all of the costs and harms caused by the product internalized into the cost charged by the hospital.
But it's not the cost. It's the manufacturer that's building it into the cost of the product. They're doing it. So there's no reason from a public policy perspective to say, well, we should also throw it on to hospitals. Why is it?
The manufacturer here, sorry to interrupt. So that's an interesting point. And I was wondering, the manufacturer was a defendant here, in that case settled. They were sued under the Product Liability Act, and that case settled. It wasn't resolved in favor of the manufacturer.
That's correct.
So you've got a plaintiff looking for another checkbook or another seller. Is that the idea?
Yes, that's exactly what's going on here.
Why does the Product Liability Act, and I know I'm using up all your time, but I apologize. I think they're good questions anyway. Maybe I'm alone on that. But why does the Product Liability Act then impose liability all the way up and down the stream of commerce?
Well, the idea is that it's possible that the manufacturer may go bankrupt. Let's say the manufacturer isn't a deep pocket, isn't there. And then so we'll also hold accountable, all those who are, who are doing this by selling this product. That's the basic idea. And different states have different rules on this. And frankly, Connecticut hasn't fleshed this out very much. But here you had the manufacturer was sued and paid. And then the claim is, well, we want more for the same injury and for the same exact theory that you're both one and the same. So from a public policy perspective, no, that's bad public policy. And particularly because what it will do is it will harm patients, because hospitals inevitably would then say, well, we will only purchase from the large producers, the large manufacturers, and that will sap the innovation that's needed in this area. Now, I don't think this court has to go there on that. I think that the sales service distinction that this court has already adopted years ago, and the legislature didn't overturn it. It's well established that when the Supreme Court adopts a rule and enough time that goes by, legislative acquiescence takes over. They didn't overturn Zakiki. They didn't. They've allowed that to be in place. They could have, and they didn't. So that in and of itself makes Zakiki strong precedent here, because the legislature didn't act in response to that. It is true, by the way, that the blood shield statute, was eliminated, but the test that Zakiki adopted for all products has continued. And also there's the appellate court decisions that were decided a long time as well, and they weren't legislatively overruled. And I believe that my time is almost up. Yes.
Counsel, in the last 30 seconds, let me ask you a quick question. Then what is the purpose of the markup of 200% or 400%, if not to create a profit center for the hospital?
Well, the purpose would be the overhead, right? So we don't, like, for example, the question before is we have to have personnel and certain equipment and things like that that they don't charge for, and that's what gets built into the markup. Now, again, I don't think that's a relevant factor here, but that's, you know, in terms of this business, that's why it happens. And there is a Superior Court decision on this right on point, because it doesn't take into account whether the hospitals actually collect that money, and it doesn't take into account overhead. Ultimately, what matters is the relationship between the plaintiff and the defendant.
Thank you.
Actually, Attorney Rigg, Justice Dario wanted to ask a question earlier of your sister counsel, and you and Justice McDonald sort of touched upon it just now, so I'm going to ask you the question that he wanted to ask, and then I'm going to ask your sister counsel. If the cost billed was zero, or the cost is billed at an upcharge level that we have here, what is the jury to make of that? That could have been for myriad reasons, maybe insurance. Are we sure, or can we be sure how that was broken out?
No, you know, under Connecticut statutes, hospitals are required to file their contracts with insurance companies and other payers of medical services, and that's when they negotiate lower. So the amount that's billed does not represent the actual amount that is ultimately paid for the medical services or the device. I think it is worth noting here that the devices represent less than 30% of what was actually billed. There were, imagine this, going in for a surgery and nobody's there, just the doctor, no anesthesia. I mean, this is a service that's provided by the hospital. And yes, it bills it back, and there are other things like overhead that go into what's billed. But also whether in the health insurance companies pay for it is different, and there's no evidence here that, you know, what was billed is what was actually paid. And I mean, in experience, you know, that just doesn't happen. That the amount that's billed is never what's paid.
I suppose on the other hand, though, you do have marketing to patients. For example, the Da Vinci machine looks like a giant octopus. That is actually marketed on television and directly to patients. What do you do about that?
Well, that could be a circumstance, Your Honor, in which a patient says, I'm going for this, but the Da Vinci, as I understand it, it's a machine. It's not, and so it's
Mm-hmm.
You know, they use it to perform a type of surgical procedure. It's not an, you know,
Mm-hmm.
it's in and of itself, it's not an implant, it's not a suture, it's not.
Mm-hmm.
But I mean, literally, what we're talking about here is that would mean that hospitals would be strictly liable for sutures, stitches, glue, medication, everything. You know, so that people, let's say when the vaccine comes out, you know, well, if you go to the hospital, that means that the hospital's in the business of selling the vaccines as opposed to, say, Pfizer.
Okay, thank you. I think Justice Ecker has a final question.
I just feel like I need to get clarification of something you said in response to the Chief Justice channeling Justice Doria. You know, I did enough False Claims Act work as a private lawyer for all my alarm bells to go off. You know, if a hospital is charging Medicaid, Medicare, you know, and billing, taking its overhead and calling it a charge for a medical device, that's criminal conduct under federal law. Are you saying, I mean, I think, I'm not adjudicating the matter, sir, you know, but just for purposes of discussion, that's a very serious problem based on my understanding of how the False Claims Act works. Are you saying that's what the hospital is doing? That they're mischarging?
No, they're not mischarging, Your Honor. I'm basing what I said on the case law, which is that it's acceptable to charge a markup and still not be in the business of selling a product, and that the markup is based, and this is discussed in my appellate brief, that the markup is based on overhead to the hospital, that and part of the industry standard.
Overhead completely unassociated with the product, but for other stuff that you can't charge for. I mean, I don't know about that, Mr. Riggs, but I think we should be careful before we adopt that point of view anyway.
Well, I can only go by what the courts have, or I should say that's what I am going by is the case law that I've discussed and what that case law says.
Thank you, Attorney Rigg. You have anything, a final statement?
No, Your Honor. Other than I believe that the summary judgment was correctly granted here, and that this court should follow what every other court in the country has also decided.
Thank you, Attorney Fusco.
Thank you, Your Honor. Just basically the Bristol Hospital here is seeking blanket immunity from liability for hospitals for these medical devices that plaintiff believes they've shown through the evidence that they are in the business of selling. Zichichi specifically found that the blood shield statute that was crafted very narrowly applied there, and necessarily adopt the sales service standard that learned counsel proclaims it. That reliance on Zichichi has been criticized as fact. What's important there is that it's the legislature could have enacted a statute specifically to exclude hospitals from liability, and they did not. They chose not to. Regarding the Farrell case.
Counsel, there's a question from Justice McDonald. I'm very sorry, but there's a question.
Counsel, let me ask you, we've been going through a lot of hypotheticals. If I can't even make up the bizarre hypothetical, but if a patient is at a hospital and getting an MRI test, and the MRI machine malfunctions and, I don't know, zaps the patient in the MRI machine, is the under your theory of this case, is the hospital on the hook as a product seller of an MRI service?
No, Your Honor, because right there it's an MRI service. They're not selling the MRI machine to the patient. They didn't buy it and resell it. So when you take equipment like an MRI machine, or even one of the cases relied upon that counsel says everybody in the country has, found they're not a product seller, it's not entirely accurate. The cases that have looked at this have found in those specific cases the hospital is not a product seller. And for example, a scalpel that the surgeon used and he injured himself, sued for product liability, not a product seller. So it would not include things like an MRI machine. It's medical devices, usually implantable. The hospital buys and sells on a regular basis for profit. And I would just like to get back to Your Honor, if I could. The Farrell case specifically found that it was an issue of fact of whether or not the hospital was a product seller. Okay, Judge Ugadi. Let's see. So there was no claim of a product liability against the physician in Farrell. And I would like to address the sales service transaction. What Bristol Hospital also wants this court to find is a broad policy that it's a subjective opinion of the patient or the consumer that drives whether or not the status of the hospital is a product seller. What they're trying to say is that, even by admitting, if they admitted we buy, sell, we make a profit on a regular basis, we make a ton of money. But if the patient doesn't know that, we're not a product seller. And to get back to, I believe it was Justice Eckert's auto sales example, if I go to get my car serviced and they tell me that, oh, you need all the service, but I decide to buy a car instead, then the auto dealer and the auto manufacturer are not product sellers if that car turns out to be defective. So the subjective reasoning for going into this whole principal part of the transaction, as Justice Eckert said, is a bit mucky. And it probably should not be relied upon. Maybe it could come into play, but the primary criteria, the objective criteria that this court could use for a broad policy is, do you fit under the CPLA? Are you substantially involved in bringing this product to market? Do you get a financial gain? Do you take title to the product? And then you can go into any sub issues that you may need to. Bristol Hospital fits the criteria in this case. They could seek indemnity from the manufacturer, addressing the financial burden issue. And by saying that, only in the case of bankruptcy, could the hospital be liable, that's an unworkable framework, because then you have to go through and wait till the manufacturer goes into bankruptcy, and then it's too late to sue the hospital, and then they fight it anyway. The point here is strict liability includes all people in the chain of distribution. My time is up, but I have just one last comment, Your Honor, to correct a statement on page A207, where Ms. Roth, lines 5 to 9, actually, Bristol Hospital does actually advertise, market, or promote transvaginal tape, transobturator tape, and sling procedures. Wouldn't you agree? And she says yes. That is the testimony plaintiff was referring to that contradicts the affidavit. Thank you, Your Honors.
Thank you very much, counsel. With that, will be adjourned until tomorrow morning at 9:30. I want to thank counsel. We had a spirited bench, and so I thank you for your patience, but the questions were very important to us, and that's why I extended the time a little bit. Thank you for your patience. And I'll see the justices in the virtual conference room. Thank you very much.
Thank you, Your Honors.
Thank you.